Hello, good evening, guys. It's Thursday, the 18th of April. Not long for Easter, Good Friday tomorrow. Yeah, what basically, I'm talking about some criminal law today. I'll come out of boxing, well, for good, I think. It's for my own beneficial benefit. Sustained front lobar damage, causing me distress in my hands and my limbs. But anyway, furthermore, as you see, a lot of my study in constitutional law, politics, going to criminology. So we talking about provocation. Provocation is something, an act of a speech that makes someone angry in a discretion towards their subject. According to the Court of Appeal, Smith 1998, for all ER 387, there is no difference in types of characteristics which are relevant to the gravity of provocation and the standard of self-control. Lord Simon in Camplin said that his reasonable person, not unusually excitable, pugnacious or ill-tempered, these character traits are inconsistent with the Lord Diplock in Camplin called the powers of self-control, as everyone is entitled to expect that his fellow citizens will exercise in society as it is today. Presumably, he is sane. Whether he is depressed is not settled, but it would be inconsistent with the present understanding of which Camplin that depression arising from a clinical cause such as premenstrual tension, see below, could be considered before Camplin it was accepted that he was not drunk. Camden is the victim of this Criminalisation Act, at least if the intoxication was not self-induced. McCarthy, 1954, to QB 105 of Ward Rope, 1960, Criminal LR 770. The 770, I'm guessing, is like the candidate number. Both Canada and New Zealand have authorities which hold that drink can affect whether the accused was not in fact provoked. So the drink hasn't taken control of his mind, that has made him provoked to do the, I think it's murder charge. I was reading it yesterday, but we're on the next page of it now. CRNS 214 and Barton 1977 1NZLR 295. There is Old English authority to like effect. Thomas 1837 173 ER 356. So this is the solicitors or the juries. You have the people that are fighting the defendant and defending. There's a defendant candidate's number. But the law seems settled that drink has no effect on the standard of reasonables. The modern explanation is the intoxication is in general no defence to a crime. So basically, saying that because he's could be intoxicated, it's no defence that he had the right to go and intent or malicious to kill. I'm not quite sure of the story because it was yesterday when I read it, and obviously it wasn't a subject where I'd got to study it, and it's not exactly. I'm in the judicial review as a solicitor, so I didn't really take on board, but I would have done if it was the case that I was in the Old Bailey or the House of Commons. The previous is that intoxication is in general no defence to a crime. More halt above this previous explanation was that intoxication was a temporary characteristic, and such a trait was not one of those which would be attributed to be a responsible person. Furthermore, it is inconsistent with the idea of a person of a reasonable self-control. However, self-induced glue sniffing may be a characteristic of a reasonable person. Moreover, the Lords moved away from the law as stated in law that a characteristic had to be sufficiently permanent as it appears. The permanence is no longer a requirement. The House of Lords also stated undue emphasis should not to be placed on the need for the accused to have a peculiar characteristic. The accused's circumstances, such as his history, are relevant. So his history, is he abruptive on his history records? Is he that way inclined? What is his circles that he hangs about in? Little things like that. You've got to look at the implications. The gravity of the provocation. What made him angry? It appears it's still measured by reference to characteristics which distinguish the accused from ordinary people, and the provocation must still be directed at the trait. What set the cause off? What set him to act in that mannerism? Moral Dryden, 1995, for all ER 987 CA. And Humphreys, 1995, for all ER 1010 CA. Candidate authority, I think it means something like that. Exemplify the proposition that the jury must consider any characteristics of a fairly permanent nature, such as a obsessional and eccentric nature in Dryden, and attention-seeking personality coupled with immaturity in Humphreys, which affected the gravity of the provocation. Glucinov in having an obsessional personality and possessing an attention-seeking complex, respectively, were traits which distinguish dependents from ordinary people. It should be noted that even if the relevant characteristic is imputed to the reasonable person, the defence fails to if a reasonable person would have acted differently from the accused. For example, in Dryden, the jury would inevitably have rejected the suggestion that to go in, deliberately put on the holster, come out with the loaded gun and fire it to kill. That was a malicious with intent to kill. With something with the self-control of a reasonable man would have done. I say that as intent to kill. Per Lord Taylor, CJ, accordingly, physiological disorders fall within syndrome had affected the accused's personality. It became a relevant characteristic. Intent to kill, but was he provoked to do it? What was the cause of the shooting? Was he threatened? Was his family threatened? Little things got taken into consideration. Besides a list of the permissible and impermissible characteristics, there seems to be a distinction between two different types of characteristics. Type is always relevant into this category: full age and gender. The second type consists of matters to which the provocation is addressed, such as physical deformity mentioned in moral. I don't believe in any kind of murder, but what was the provocation subject to make him go and do the shooting? What distinguished his mental behaviour to pull out a gun and shoot somebody? This division comes from Camden itself. Though it has been obscured, the provocation was not directed at the body's age, but his age was a characteristic which was to be taken into account. Adopting this approach, the judge should first inquire into be taken into account. Adopting this approach, the judge should first inquire into which category the trait falls. If it is of the first type, it is also relevant, but it is of the second one. It is relevant only if the words or acts were directed at it. There is, of course, a third category, including excitability, which is never relevant. This type are of those which are relevant to the stand of self-control of a reasonable person. I've got a lot of self-control. As you know, you've seen a lot of people provoking me on social media. I try and act it in a professional mannerism. Try and ignore the consequences. Furthermore, I've got professional bodies protecting my well-being. The second is relevant to gravity of the provocation. For example, intoxication is not allowed the effect to the standard of a reasonable person, but as taunt relates to alcoholism, the characteristics can be considered when assessing its gravity. If the characteristics is one which is permissible to take into account because of the provocation is directed at it, the law presumably excludes from the defence of provocation no subject to what might be called untrue name-calling. Take, for instance, a non-paedophile who is called a child molester. Come to me in a minute. I was talking about him earlier, but in that he got taken out of the House of Commons for calling someone a paedophile. What was his face? It comes to me in a little while. I'll talk about it in a bit when I come back to it. It was around 1989, I believe. He got taken out of the House of Commons. He called one of the MPs a paedophile. He got his seat taken off him. But this is a different story anyway. When assessing the rates. For example, intoxication is not allowed to affect the standard reasonable person if taunt relates to alcoholism. The characteristics can be considered when assessing its gravity. If a characteristic is one which is permissible to take into account because of the provocation is directed at it, the law presumably excludes from the defence of provocation those subjected to what might be called untrue name calling. Take, for instance, a non-paedophile is called a child molester. He cannot rely on the taunt because it is not addressed to any characteristics he possesses, yet it may well be that he deserves a defence. The first case to apply, Camplin was nil. 1980, 71 CR APP R331. The accused, a chronic alcoholic for 10 years, had been deserted by his woman and he attempted to commit suicide. Happens a lot in relationships. My answer to that is don't put your life on hold for a lady, or vice versa. There's plenty more fish in the sea. Dry your eyes, mate. A few days later, he was drinking again. A friend spoke despairingly about his former mistress and made a homosexual suggestion. The accused responded by picking up a heavy ashtray by striking him more than 20 times around the head, thereby killing him. That was the intent to kill, absolutely. More than 20 times. Once, just to try and disable him, but that's just taking the biscuit. The Court of Appeal held first that while applying the reasonable man test, the juries should be guided by their own individual and collective reaction to the suggestion that a reasonable person could or would have not reacted in a certain way. Secondly, characteristics which were to be considered under Camplin had to have a sufficient degree of performance as to be regarded as part of the accused ethnicity. Glue sniffing immoral has a characteristics which could be taken into account when determining the effect of the taunt might have on an ordinary responsible person for the provocation. Would it affect a solvent abuser more than it would a non-glue sniffer? The taunt was aimed at characteristics of glue sniffing. Battered woman syndrome may fit into the first class, something transitory such as suicidal disposition of short duration. A short duration was irrelevant. According to Newell, last there had to be a causal link between the particular characteristic and the nature of provocation. There was none such on the facts. Requirement that a provocation must be directed at the irrelevant characteristics of the accused have been criticised on the ground that it complicates the application of the reasonable person test. But the principle is sound to say that the accused in Rainey above was legless. Legless meaning totally intoxicated. Might be provoking, but the fact that he had one leg is relevant if he is taunted as to the colour of his skin. The court did not say that the chronic alcoholism could or could not be a characteristic. The fact there was the illness had nothing to do with the words by which he was provoked. The court refused to leave the appeal. Card, Cross and Jones, Criminal Law 14th edition, Butterworth, 1998, criticised Newell at P200. There is no good reason why the reasonable man should be invested with a transitory condition with the effects of the gravity of the provocation to him. On the approach, a temporary state of mind such as anger arose of the other's behaviour could be taken into account. Temporary physical mental states such as impotence could be taken into account. Lord Gough, that's it, Gough, is the one that called our matey a paedophile. In Moore expressly said some physical conditions such as eczema may be maybe not that Lord Gough either, may be transient in nature, yet certainly be taken into account. The subject of taunts, accordingly, Newell is no longer correct on this issue. The second case to apply in Campling was Raven, 1982, Crim LR 51. A jury at the second case can apply Campling versus Raven, 1982. The jury at the Central Court, Criminal Court, was asked to place itself in the position of the reasonable 22-year-old man with the mental age of 9, who lived in squats for 2 or 3 years. Quite difficult position to emphasise oneself as being in. As in Campling, age was a material factor, but in Raven it was mental age with counted. It may be that the outcome in Raven was incorrect because of the provocation was not directed at the mental age. Furthermore, the provocation was not linked to the accused's participation in squats, yet the judge directed the jury to take the fact into account. Raven is incorrect if the Privy Council case noted below is taken as authority in England. Raven is at present in a case in Council case noted below is taken authority in England. Raven is at present case in limbo, similar to Raven is Burke above, where the victim in Portune in 19-year-old limbo. No, a 19-year-old churchgoer. Traits had to be considered. Burke is another case where there is not a sudden loss of self-control. The accused walked off the dance floor, got a knife, returned, stabbed the victim. In Campling itself, Lord Simon suggests that a female accused suffering from PMT, it's basically PMT is thingy of the month, being pregnant or undergoing a menopause, where features with which the reasonable person might be endowed. The Court of Appeal in Al-Luwali above declined to consider appellant's contention that she had a characteristic of learned helplessness, which was a part of the battered woman syndrome, because no evidence to support it had been led. The position might have been different if such evidence had been adduced. Lord Taylor, CJ, applied the words of North J in the New Zealand case of McGregory, 1962, NZLR 1069, that the Court of Appeal had earlier done in Newell. Although the accused had been severely maltreated by her husband, there is no evidence that she was marked of the distinguished from the ordinary woman of the community. Accordingly, her plea failed. Nevertheless, the court did not totally rule out the situation which the defendant could rely on the battered woman syndrome. The accused's successful pleas of diminished responsibility is difficult to square with the principal plea provocation. The latter defence in her case was partially based on her contention that her response to the victim's behaviour was responsible, whereas diminished responsibility is not grounded on reasonableness. Indeed, the USA, the syndrome has been used by the battered children and homosexual lovers. In England, evidence of battered husband syndrome was led in Irons 1995, 16 CR App RS 46. A difficulty with the syndrome is not that all battered women suffer it, with the result that those who do not fall in the proposed definition cannot align it. It must be said that the definition is only a working one, that is a nature of fact suffer from them. The US definition may not become the English one. One criticism may be dead male directing his onslaught at a characteristic, it suggested that the rule should be whether the characteristic excuse of the fatal response. This defendant's control over her actions may be reduced in comparison with those of a court to do not criticise the trial judge's reference to accused ethnicity, martial status, self-control of a reasonable woman, and the provocation directed at them. In Humphreys, the accused, who had a history stabbing her wrists, who had slashing her wrist to gain attention, killed the victim with whom she was cohabiting, a partner or whatever. He has said to his son and two friends, "Well, be alright for a gang bang tonight," and he told her on the same evening, when he arrived home, to discover that she had slashed her wrist, that she had not made a very good job of attempting suicide. She admittedly stabbed him with a kitchen knife. The court heard that their immaturity and attention-seeking traits were characteristics within Camberlin, and that the taunts were directed as these abnormal aspects of her personality. Two contrasting to the above are Roberts 1990, Crim LR 123, and Arley 1989. I was age 6. Crim LR 736 in the former Court of Appeal held that on the fact of a reasonable man was 23 years old, suffering from a large degree of deafness and having a consequent speech impairment. However, the fact that he reacted with a rational explosion of violence was not a trait of the reasonable man, because excitability was to be disregarded by the jury. In the latter case, the victim seized the accused, aged 20, at a disco and punched him to the ground. The accused stabbed him to death. The Court of Appeal held following nil that there was no causal nexus between the accused's age and the provocation. Therefore, the age was irrelevant. The question was therefore on the facts of how a reasonable 20-year-old reacted. But would a reasonable person of, say, 35 react? His sex was not also irrelevant. No reasonable jury would have considered that his age or sex affected his behaviour. That's very, very unfortunate. The man's partially deaf, got a speech impairment, and he's got that treatment by his girlfriend. It's devastating. The authority of the English case of Newell, Raven, Humphreys, Dryden and Thornton No. 2 in retaliation on mental characteristics was for a while undermined by the Privacy Council advice in Lockfett Fuan versus R 1997 AC 133. The trial judge did not refer to the fact that the appellant had brain damage, which caused him to lack self-control. Lord Goff, delivering the opinion of the majority, referred to Camberlin and said that the accused was imbued in the powers of self-control expected of a reasonable person of the same age and sex he was. But it is an entirely different question whether it is mental infirmity and defendant which impairs his powers of self-control should be taken into account, and indeed it is difficult to see how it can be consistent with a person having the power to self-control of an ordinary person. Accordingly, with the person having the power of self-control of an ordinary person, accordingly there is no basis upon which mental infirmity of the part of the defendant which has the effect of reducing his powers of self-control that it is to be expected of an ordinary person can, as such, be attributed to be an ordinary person. A bit similar to myself after kicking, but I've got self-control. I pick myself up and move on. The effect would be that the infirmity of the defendant, it is itself the subject of taunts by the deceased, may be taken into account, going into the gravity of provocation as applied to the defendant. Reduced by mental imbalance would mean that the law diminished responsibly was to be incorporated into the law of provocation. Such a result was not intended by the Parliament. Lord Goff accepted the provocation could be cumulative, but expressed no option on the effect of cumulative provocation on the battered person syndrome. One point, the authority is that although the case is Privacy Council one, there is only one law lord in majority, the other law lord there formed the minority. It was not that there was the four law lords, it was in minority, majority, and as someone been the case, England's courts continue to apply the Court of Appeal authorities which are blinded on them, whereas the advice of Privy Council is only persuasive authority. So there's quite a few complications to what they're going to take the victim into consideration of his illness. One criticism of Luke that is that fetal age was accepted by the Lords in Cameron and relevant characteristics. Young people may be prone to react with less self-control than older persons. If age is included, it would be hard to exclude mental age exemplified by immaturity in Humphreys. The Court of Appeal in Campbell No. 2 said that luck was compelling, but it was a matter of fairness. The mental abnormality should be attributed to the reasonable person. The Heir of Law urgently needs clarification by the Lords. Lord Godfrey Moore said that the reasonable person test in provocation was not the same in the tort. It was not concerned with reasonable foreseeability and reasonable care. The functional test is only to introduce a matter of policy. A standard of self-control which has to be complied with. The provocation is to be established in law. It can be entirely consistent with the law and stated in S3 of the Act 1957 Act to direct the jury simply by reference to a hypothetical person having the power of self-control to be expected of an ordinary person of the age and sex of the defendant, but in respect of sharing such of the defendant's characteristics such as his illness as they think will affect the gravity of provocation to him. Mental illness can submerge different defects. To summarize the law of Campbell No. 2, Parker versus Smith, characteristics such as mental infirmity to be attributed to the reasonable person. These traits are attributed not just when assessing the gravity of the provocation, but also the reasonable person's potential for loss of self-control. It should be remembered that the reasonable person is also imbued to the accused's history and circumstances. However, still excluded are excitability, pugnacity, explosiveness, and intoxication. So yeah, if he's got all that illness and he's losing self-control through alcoholism and other stuff, it's going to exempt towards explosiveness. Mental torture on his own self, and he's putting more stress on his illness. So they've got to look at the facts, but what are the functions of a judge and jury? I'm going to read that in peace. I'm going to love you and leave you, but that's a bit. This is all my knowledge I'm gaining, extra knowledge in criminology, criminal law, how the juries go about their service, how the solicitors help fight the defendant, and so on and so forth. It's a case in every aspect, even the victim is guilty or not guilty, as in that young lad, he's guilty in a sense, but also he's got mental discharges which should be subject upon. That's probably why he's got a solicitor fighting his case, because the woman technically should have rung the alarm bells. She's with someone that's not very mentally well, not stable. You got to look into all different aspects. She should have rung the bell, rung the alarm. If she loved someone that's mentally not well, you got to take it into consideration. Try and help the man. He needs help, and they should have helped support him among the police, rung the alarm, and then attack the prosecution in a civil manner. Thank you for watching. It's 30 minutes of reading. Like I say, that's my education. I'm taking it further into a pill of criminology. I've got social law after this book. I'm on page 80. I've got another 400 pages, but thanks for watching. Take care.